The Fourth Circuit has just affirmed that ICE is not allowed inside religious institutions during their enforcement measures. This is the decision of Philadelphia Meeting versus DHS, the decision from the Fourth Circuit that came out today on August 18th. Now, I would love to say that this actually affects everybody in the United States or even everybody in the Fourth Circuit, but as far as I can tell, this injunction only affects the 8 named plaintiffs. Basically, their churches are protected, and everybody else in the rest of the Fourth Circuit and in other jurisdictions have to hope that ICE doesn't go to their places of worship. Regardless of who this affects, the arguments used in this case are very good. Currently, there are 2 other cases, one in the DC Circuit and one in the First Circuit, that are seeing the same kind of case, basically saying that ICE should not be allowed to arrest immigrants or invade church spaces because it's a stifling of religious expression under the First Amendment and also under the Religious Freedom Restoration Act of 1993. So here's your history lesson. In 1993, the INS, the Immigration Naturalization Service, issued guidance on when law enforcement, their enforcement arms, are allowed to engage in enforcement measures inside of church buildings or during church events and that sort of thing. They said that they're not for most cases. And since 1993, for many, many iterations, you actually needed written permission from a supervisor if you were going to engage in any type of enforcement measure inside a place of worship. In 2021, Secretary Mayorkas made it even stronger. You're not allowed to do any enforcement at churches unless it's a national security risk or you're in hot pursuit of somebody that had just crossed the border, or if there's dangers of destruction of evidence, or if there's danger of imminent bodily injury or death. Now, in 2025, when the Trump administration took over, an acting DHS secretary issued their own memo that says that we're not going to stifle ICE in any way, and they have to, quote, use common sense. So many church groups started suing, citing violations of the Religious Freedom Restoration Act. So another history lesson, the Religious Freedom and Restoration Act was passed in response to a 1990 Supreme Court case called Employment Division versus Smith, which basically said if you have a law not intending to affect religion, but as a side note, it actually does affect religion, then you can just apply a rational basis review and not strict scrutiny. A lot of groups within Congress panicked after this decision, and they passed the Religious Freedom Restoration Act in 1993, 3 years later. And they basically said that we're going to apply strict scrutiny, meaning if any law, regardless of any law that comes out of Congress, has the effect of stifling religious expression, then they have to have a very compelling reason, and they have to use the least restrictive means under strict scrutiny. And when this case reached the fourth appellate group, they basically decided we're not even going to look at the First Amendment issues. We're going to decide this on the Religious Freedom Restoration Act, and determining that, no, they did not provide a compelling interest on why they had to do enforcement actions and why they had to rescind the 2021 Mayorkas memo. Thanks for listening. If you want to see a full article on this case, go to The Migration on Substack.